Next up, we have a panel discussion on legal strategies to prevent gun violence and keep firearms out of the wrong hands and the wrong places. We have the honor of having Nina Vinik moderate the panel discussion. Nina manages the Joyce Foundation's grant making in support of evidence-based policies and practices to reduce gun deaths and injuries. Under Nina's direction, Joyce has funded some of the nation's most significant research into the impact of state prevention strategies. She also has focused on developing broad stakeholder coalitions to advocate for common sense gun laws to keep our communities safe. Nina is based here in Chicago, graduate of the University of Chicago Law School, and Nina will moderate and will introduce our panel of distinguished speakers. We'll again leave time for audience questions. Please jot down your question on a note card and pass them to the center aisle and we'll collect them. Please welcome Nina Vinik.
Thank you, David, and thank you all for being here this afternoon for what has already been a tremendous program, and I know will continue to be as we move to the next panel. So the next panel is a bunch of lawyers. We are here at the ABA, and we're going to talk now for the next hour or so about the law and policy of firearms in the United States, to offer an overview of the regulation of firearms in our country, the legal framework that undergirds that regulatory environment, and finally, we'll talk about how lawyers in the private bar can get involved in supporting gun violence prevention efforts. So let me introduce our panel. We're going to hear first from Jonathan Lowy. John is the director of the Legal Action Project at the Brady Center to Prevent Gun Violence, where he leads a team of attorneys providing pro bono legal representation and assistance to governments and public officials in defense of reasonable gun laws, as well as to victims of gun violence in lawsuits to reform dangerous gun industry practices. And in fact, John was recently lead counsel in a case you may have read about in Missouri, which resulted in a multi-million-dollar legal settlement on behalf of a family where a gun was purchased from a pawn shop by a mentally ill young woman who used the gun to kill her father. John represented the family and reached a landmark settlement in that case, which maybe we'll hear a little bit more about. John is a graduate of Harvard College and the University of Virginia Law School, and he's also the author of a recent law review article on the right not to be shot, which I recommend was published last year in the Georgetown Journal of Law and Public Policy. After John, we'll hear from Daryl Miller. Daryl is a professor of law at Duke University, where he focuses his scholarship on civil rights, constitutional law, civil procedure, state and local government, and legal history. Daryl is also the co-author of a forthcoming textbook on the Second Amendment law and theory, which will be an exciting addition to the legal academy's treatment of the Second Amendment and issues around gun violence. Daryl attended Harvard Law School, as well as Oxford University and Anderson University. And finally, last but not least, we'll hear from Kaveri Vaid. Kaveri is an associate at Paul Weiss, where she focuses on white-collar criminal defense and complex civil litigation. But for purposes of this afternoon's conversation, she's also been a lead attorney on a pro bono gun violence prevention initiative that she'll talk more about. Kaveri has both a JD and an LLM from New York University School of Law, an MA from Columbia University, and she got her bachelor's degree from Williams College. Before practicing law, Kaveri was a grant maker at the Carnegie Corporation in New York, and also a Teach for America teaching fellow. So let's welcome our panel, and we'll start with John Lowy.
Thank you, Nina, and thanks, everyone. We've heard a lot about the gun violence problem in America. I'm going to talk to you a little bit about what our political leaders, in their infinite wisdom, have done to address it. It won't take me very long. First, there are about 3 major federal gun laws. The fundamental one is the Gun Control Act, which was enacted in 1968, which essentially prohibits certain people from buying and possessing guns. Felons, certain mentally ill people, and it's been expanded to domestic violence abusers and a few other categories. Second, there is the Brady Law, which was signed by President Clinton, which requires that firearms sales that are made from licensed gun dealers that a background check be done at those sales. Third, there is the National Firearms Act, which is often referred to as the machine gun ban. It's not really a ban, but it strictly regulates and restricts the ownership of automatic weapons, such as machine guns. And that really is about it for federal gun laws. When you hear Wayne LaPierre say we have, I forgot how many thousands of laws on the books regulating guns, he's dividing those into a lot of subparts. Those laws do a lot of good, but they leave a lot of gaps. Probably the biggest gap is that under federal law, people are allowed to sell guns even if they do not have a federal firearms license. So long as you are not engaged in the business of selling firearms, you can sell guns. And when you sell guns as an unlicensed person under federal law, you are not required to do a background check. So myself, I think my fellow panelists, I don't think any of us are federally licensed gun dealers. In most states, we can sell guns, no questions asked. And as a result of that, an estimated 22 to 40% of gun sales take place without a background check. And now, with the internet, you can go online, go to sites like armslist.com, and you can find many guns for sale by unlicensed sellers. Many of them, by the way, selling a significant number of guns, which would seem to indicate that they actually are engaged in the business of selling firearms. Some of the other gaps, there are a number of prohibited or people who one might think should be prohibited from possessing guns who aren't. Terrorists who are not allowed to fly in airplanes, for example, are allowed to purchase firearms under federal law. We used to have an assault weapon ban under federal law that lapsed, and it is no more. So under federal law in most states, you can buy the semi-automatic versions of some of the automatic arms that are banned under the NFA. So AK-47s, AR-15s, and the like are legal under federal law. Other gaps are created by the restrictions on ATF's enforcement ability over licensed gun dealers. ATF has limited resources and has some legal impediments that prevent it from fully enforcing the law. And as a result, many gun dealers are not even inspected. And we find a serious problem of what we call bad apple gun dealers. And the problem of crime guns in America can be pretty much boiled down to the bad apple gun dealer problem. That oversimplifies a little bit, but the fact is about 90% of guns recovered in crime in America are sold by about 5% of the gun dealers. If I had a PowerPoint, I would leave it up right now to let you think about that. 5% of gun dealers in America sell about 90% of the crime guns. And on the flip side, about 90% of gun dealers in America sell no guns traced to crime. So that tells us that the overwhelming majority of gun dealers are doing the right thing. They're responsible gun owners. They care about where their guns are going to. But you've got this small group of bad apples that are responsible for a lot of the problem. So over the past 20 years since the Brady Law was enacted, Congress, rather than stepping in to fill these gaps in the law, has actually created new gaps in the law. Here are a few examples. One, the Protection of Lawful Commerce in Arms Act, which was enacted in 2005, signed by President Bush, which gives gun dealers, manufacturers, and distributors unique protection from civil liability that no other industry or people in America have. It doesn't give them complete immunity, and we've had a lot of success at the Brady Center. Nina referred to one of our cases where we've been able to litigate them despite what I'll call PLACA. However, it does make gun violence victims into second-class citizens. That's literally true. They don't have the rights of anyone else. And it insulates bad apple gun dealers and manufacturers and distributors who supply them from liability in a lot of cases. What's called the TART amendments prevent the federal government from disclosing a lot of data about where our crime guns are coming from. And it's a exemption from the Freedom of Information Act, FOIA, that doesn't exist anywhere else in the law. We shield this information that's damning to bad apple gun dealers in a way that we don't for any other type of information. Before the Brady Bill, there were some other special and dangerous exemptions for the gun industry. One is under the Consumer Product Safety Act. Guns are the only product that are exempt from federal product safety oversight. So federal government can recall and require safety devices for bunk beds, bicycles, BB guns, but not real guns. And there's also the Firearms Owners Protection Act, which, as I referred to before, limits ATF authority. One thing it does is it says that ATF can only do one spot inspection of a gun dealer per year. So once a dealer has seen the ATF for a spot inspection once, they can put it on their calendar and they know next 12 months they're home free unless there's a warrant or some sort of probable cause. Again, there's absolutely no restriction on any other law enforcement agency in America that is remotely like that. Fortunately, states have filled in some of these gaps. There are a growing number of states that are requiring universal background checks for all gun sales. So me, Nina, Daryl, Kaveri would be required to do background checks even if we were selling guns. And that is a growing number. There are a few states that prohibit military-style assault weapons and high-capacity magazines. We're beginning to see a number of states enact what's called gun violence restraining orders, which authorize the removal of guns from people who are dangerous in the moment but are not prohibited under any existing category in the law. And we're also seeing some growing appetite for state regulation of gun dealers. So states can crack down on dealers when ATF is not doing the job. That was referred to. There's a bill pending in Illinois now. briefly, let me talk to you about what some gun violence prevention advocates do about the gun violence problem. In particular, the Brady Center, where I've worked for the past 20 years. We have 3 campaigns at the Brady Center. One is the Bad Apple Gun Dealer campaign, which is to stop bad apple gun dealers. One way we do that is to bring lawsuits against them to incentivize responsible practices. Again, to put a price on supplying criminals and dangerous people that are harming people in our community. We also have outreach in the community, protests against gun dealers. Chuck's here just outside of Chicago has seen a number of our folks protesting them. Chuck's has been the top supplier of guns in Chicago for a number of years, but remains in business. The second campaign that we have at Brady is Finish the Job, which simply is to finish the job to require background checks for all gun sales in America. Ideally at the federal level, and that really needs to be done, but while Congress is considering the problem, we're going to continue to work in other states to try to have as many states as possible require background checks for all gun sales. And third, we have a campaign called Truth About Guns, and that's aimed at changing this misperception among what's now a majority of Americans that guns in the home make you safer, when actually they're more likely to kill you or your family members. So that's about it as far as gun laws. In a brief overview, I'm sure I've missed a few. I'm happy to answer more questions and discuss more of this litigation. I will tell you that there is good news. Some of this may have been somewhat depressing, but there's good news in that we are making, we as a movement are making a lot of headway, certainly on the state level, with more and more positive, impactful laws being enacted, and also in the courts. And the important thing about the courts is, and that's where I've done most of my work for the past 20 years, is it doesn't matter who's in the White House, doesn't matter who's in power in Congress. The courts are much more insulated, as we know, from special interest power, and there we have been able to defeat the gun lobby and the gun industry time and again. And so we're making major progress there. Thank you very much.
We're going to take questions at the end, so we'll hear from Daryl next.
Oh, thank you very much. Everybody hear me okay? Okay. I want to thank the American Bar Association and the American Medical Association for coming to, inviting me to speak to you. I've heard that, getting a group of lawyers together is like herding cats, and I've also heard the same thing about doctors. It's like herding cats. And I've heard that doctors and lawyers fight like cats and dogs, so I guess it's like fighting cats and dogs. But I guess it really goes to the seriousness of the issue, that there is broad agreement in the legal community among the legal professionals and medical professionals that gun violence is a problem. There might be differences about what the solutions are, but not a lot of difference that it's a problem that needs to be addressed and addressed seriously. So I'm going to give a very broad overview on the constitutional law issues here because, as Dr. Miller had indicated before, the problem or the issue with addressing gun violence from a public policy perspective is that unlike regulations on motor vehicles, for example, there is a constitutional amendment that says something about this particular type of item, and the questions that it raises are going to be continually fought about, and I want to give a brief overview about what the constitutional law structure is and some point and where it's pointing to in the future. So. What my colleague Joseph Blocher and I call the first generation of Second Amendment law dealt with one question, and that was, is the right to keep and bear arms in the Second Amendment a right that is reposed in an organization, the militia, or is it reposed in individuals that have individual purposes for owning a firearm? And most of the fights about whether or not the Second Amendment protected the right sort of dealt with that axis of division. And in the District of Columbia versus Heller case, the court came to the conclusion that it was an individual right and that people have a right to possess firearms for individual purposes, most saliently for self-defense. McDonald, by the way, the sequel that was generated here in Chicago, had to do with its application to the states and to localities. So when it was just Heller, it just had to do with federal law, but McDonald made the Second Amendment applicable to all the states. And so, as John was saying, the whole panoply of the regulatory environment for firearms is implicated by the McDonald decision, because now it's not just federal law, it's both state and federal law. So this first generation answered the question about the individual right and came down definitively on the individual right side. But it did not say that therefore all regulation of firearms are now prohibited. The most important probably carve out, caveat, safe harbor, it's got different sort of terminologies, is this statement in the opinion in Heller, which is, nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions on the commercial sale of arms. So that means that there is a lot of regulation that, as the McDonald opinion seems to suggest, is on the table as opposed to off the table. So it's a misnomer to think that the Second Amendment now implicates, or it certainly invalidates all gun regulation. Some regs are off the table and some regs are on the table. And this leads to what I think we might think of as the second generation of Second Amendment scholarship and litigation, which has to deal with two questions. What regs are on or off the table? And more importantly, how do we even figure that out? So the predominant mechanism by which the lower courts have addressed this question can be thought of as a kind of two-step process. One has to do with a coverage question. Are we even talking about a Second Amendment issue at all? The analogy here would be to like the First Amendment. If I slide a piece of paper at to a bank teller says, I have a gun, give me all the money, right? That's definitely speech, but nobody thinks of that as being protected by the First Amendment. So there are some things that the Second Amendment really doesn't, as they say, show up at all. It's not a Second Amendment question. Now, how do we understand what that is? Well, the safe harbor has provided some of that. So many felons in possession tried to challenge their convictions after the Heller decision and have routinely lost on the premise that we're not really dealing with a person, an item, a place, or a reason for having the gun that's protected by the Second Amendment. These kinds of coverage questions tend to be sort of keyed to either the history of the Second Amendment or its purpose, and we can talk a little bit more about that in the Q&A. If we're talking about a Second Amendment issue, then we go down to the sort of second prong of the predominant test in the lower courts, which is a kind of scope issue, like how much is it protected? And this is where the important sort of data and research that organizations like medical professionals really come into play, or criminologists, because it says even if we were dealing with something that implicates a Second Amendment right, is there some sort of countervailing reason why this type of regulatory regime is okay? Typically among lawyers, it's known as a scrutiny test. For if you want to get really into the weeds, it's called intermediate scrutiny, is the predominant way that courts have applied the second set of questions in Second Amendment litigation. But that's where we get to issues like trying to balance the factors. So cases, for example, where somebody has claimed the requirement that firearms be imprinted with a serial number affects their Second Amendment right, have been rejected on the grounds that even if we thought that stamping a firearm with a serial number implicated a Second Amendment right of some kind, the effect on caring about or impinging upon a core sort of Second Amendment value, either defined historically or defined in some kind of moral sense, is de minimis. The gun still works. The more that the regulatory regime seems to impact these sort of core or historical norms for the right, the more likely the court is to strike it down, although there has been precious little, actually, cases in which the courts have struck down a regulation on that grounds. One of the, not outliers, but one of the exceptions that proves the rule, again, was, I believe, here in Chicago, where Chicago had passed a law about possession of a firearm, had said you had to go and have pistol training, but then had prevented any way that you could actually get trained with a pistol within city limits. And I believe the majority said something that's just too clever by half. So that was one of the unusual cases in which it was found that it impinged too much on the right. But that is an exception. I think more than 90% of the challenges to Second Amendment regulations have, in fact, lost. And now many of these are going to be repeat players with felons who have, challenged their convictions. So the numbers might be misleading in that regard. But basically, those who support gun regulations, reasonable gun regulations, have some cause to be cheered by the results in the lower courts so far. So let me talk, before I give up the mic, about a couple of developments that I'm sort of tracking and I think is important for you to understand in terms of the constitutional environment. The first has to do with what we might think of as breaking open this sort of categorical, it's not a Second Amendment question approach. So I indicated, for example, that felons in possession have routinely been found not to have Second Amendment rights based on the carve-outs from the Heller decision. But that is starting to break down in this respect. Some persons with superannuated convictions, or some persons that have been, for example, committed involuntarily for a mental health crisis, which is also old, have said that, yeah, in the most cases, felons aren't allowed to possess firearms, and that's not a Second Amendment problem, or most persons that have been involuntarily committed, and it's not a Second Amendment problem. But in my case, it is. And so in two cases, one that's come up from the Third Circuit, one that came down from the Sixth Circuit, litigants have tried to break open that sort of categorical, it's okay to prohibit X person from having a firearm by saying, I am in a special circumstance. One of those cases, the Binderup case, the Supreme Court of the United States is right now trying to figure out whether it wants to address the question on the merits. The second development is cases that have to do not with the Second Amendment per se, but have to do with pro-gun legislation basically rubbing up against other kinds of constitutional values. The Dox versus Glocks case is a prime example of that. There's nothing in the Second Amendment that requires a physician not to ask about guns in the workplace. Somebody who works in a VA hospital, they might, that might be an odd outlier. But in general, there's not a Second Amendment issue. This is pro-gun legislation that is housed in constitutional rhetoric. And then it runs up against some other constitutional value, like the First Amendment. The First Amendment, well-settled right of physicians to be able to talk to their patients. And I think we're going to see more and more of these types of cases where you have pro-gun legislation that is articulated as Second Amendment protective legislation that ends up impacting other types of constitutional rights, and the courts are going to have to work them out. I think in closing for my brief time here, I think it's worthwhile to sort of think through in terms of the constitutional dynamics about what is the kind of world that we might want to see if you happen to be sympathetic to gun legislation or gun violence prevention legislation. And I think it's to basically have the constitutional rights there, but not in such a robust way that they get in the way of what I think we would agree would be good evidence-based policy that persons with training other than legal training are able to provide. Thank you very much.
So I'm here today to talk about what the private bar has done and what the private bar is going to do going forward. Now, as John said, the gun industry has really unprecedented immunity, unprecedented legal protections. It has successfully evaded even the most rational accountability measures. It has successfully beaten back regulations, even the most common sense gun regulations. And for decades, gun violence prevention organizations like the Brady Center and others have challenged this immunity, have fought for common sense gun regulations, and they've often had the support of the private bar. John and I are working together on a pro bono case right now in Texas. We're suing a pawn shop for the negligent entrustment of a firearm to a mentally ill person who ultimately used it to kill his father-in-law 4 hours after getting it. And these individual representations, these individual pro bono partnerships are important and they're crucial and they're going to continue. At the same time, I think it's become clear that a more forceful, coordinated response is needed. And that we're in a moment in time where, especially after Orlando, public opinion is with us, and we need to catalyze this demand for reform and accountability. And so we are. It was recently reported in the New York Times last December that 7 leading law firms have partnered with each other and with the Brady Center, the Law Center to Prevent Gun Violence, and the Brennan Center for Justice to mount a unified strategic response to the gun violence epidemic that is every bit as well-resourced, coordinated, and forceful as the gun lobby's efforts to evade accountability have been. Leading law firms, including Paul Weiss, are committing unprecedented levels of pro bono support to ensure that we address this epidemic. We are, in addition to Paul Weiss, the firms involved are Munger, Tolles & Olson, O'Melveny and Myers, Covington and Burling, Hogan Lovells, Dentons, Arnold and Porter, Kecker, Van Nest and Peters, Mayer Brown and Morris and Forster, and we are getting expressions of interest from firms large and small across the country every day. The goal of this coalition is to develop affirmative litigation strategies, creative legal theories to combat gun violence and hold the gun industry accountable. And I'll provide a very brief overview of some of those strategies here. Unfortunately, I can't go into much detail for reasons of privilege, but many of these projects are quite far along. We plan to play both offense and defense. We will challenge congressional restrictions on information sharing that John mentioned. These restrictions withhold critical data from researchers and policymakers. They handcuff law enforcement, and they make it very difficult to identify how guns are trafficked, how legal guns move to the black market, and so forth. We will challenge shoot first and stand your ground laws, which have encouraged the use of deadly force in public spaces, which have frustrated law enforcement's efforts to hold shooters accountable, and which have caused an increase in unaccountable killings that disproportionately affect communities of color. We will challenge state laws that handcuff local officials and prevent them from taking meaningful action to address gun violence in their communities. Mayors, city councils, local police officers are on the front lines of gun violence, and they often know best what reforms and regulations are needed, but all too often they are prevented from implementing these reforms by so-called firearm preemption laws. We will challenge dangerous state laws that force guns into sensitive places, and we will hold accountable irresponsible gun owners when their public brandishing of weapons involves menacing and intimidating behavior, escalates nonviolent encounters to violent encounters, and makes non-lethal conflicts potentially deadly. We will also hold accountable gun owners who do not exercise the responsibility that come with their Second Amendment rights, who don't store their guns safely, who negligently allow their guns to get into the hands of children or criminals or other dangerous people. We will hold accountable unlicensed gun show operators and unlicensed gun sellers when they sell guns without conducting background checks or undertaking even the most basic efforts to ensure that they are not selling guns to criminals or people who are not appropriate purchasers. We will hold the gun industry to the same standards as any other manufacturer or seller of products, including by ensuring that guns are designed safely and that with an eye towards minimizing risk wherever possible. And we will ensure that the gun industry's public statements and marketing campaigns take into account the many proven health risks of gun ownership, as discussed by Dr. Miller and as will be discussed by the following panel. We will ensure that the gun lobby, and specifically the NRA, is held accountable for its groundless blockading of any and all sensible gun violence prevention efforts. And we will challenge federal laws that undermine or prevent states from enacting common sense gun reforms and imposing responsible restrictions on the carrying of guns, including the anticipated federal Concealed Carry Reciprocity Act. These are just some of the strategies that we're working on. In the coming months, we anticipate commencing our first public actions. We are adding to our ranks on a daily, weekly basis. And I think in closing, there's a tremendous amount of work for the private bar to do. We have manpower, we have resources, and there's a lot of work to be done. And I encourage you, if you have any questions, to please get in touch.
So we do have time for questions. So again, please write your questions on the note cards and pass them to the center. And while you're doing that, I'm going to start, I think, with a question for each of the panelists. And I'm going to start with Kaveri. So the issue of guns and gun violence is, I think, perceived in many corners as a controversial issue, as politically hot. The NRA, of course, is a powerful lobby group. And I'm wondering, at Paul Weiss, was there any concern about the firm getting involved in this area? And if you can also speak for the other firms that you mentioned that have signed on to this coalition, has there been any concern about risk or pushback about the controversial nature of the issue?
I mean, we're certainly not unaware of the controversial nature of the issue, but I think, for Paul Weiss, social justice pro bono is really ingrained in the history of our firm, from working with Thurgood Marshall and the NAACP Legal Defense and Education Fund to assist on Brown versus Board of Education, to much more recently representing Edie Windsor in her successful challenge to the Defense of Marriage Act. We as a firm have very strongly believe in our obligations as lawyers and as citizens, and to advance social justice, to make ours a more fair, equal, just, and safe world and country. And I think that really drove this effort forward. We've had tremendous support from the chairman of the firm, Brad Karp, and I think he really set a very powerful tone, both within Paul Weiss and for the other firms who were willing to be named publicly. And my hope is that as more firms are willing to be named publicly and are willing to take this on, we can really speak with a more unified and powerful voice.
Great. And this may be the most important question, which is, what is the name of the coalition and how can lawyers get involved?
Thank you. So it is the Firearms Accountability Task Force, and I believe we're working on a website, but in terms of getting involved, I think you should feel free to please contact me.
Great. John, I'll ask you a question next, and that is if you could talk a little bit more about the so-called Docs versus Glocks case that a number of speakers have mentioned. John was co-counsel in that case. It had a somewhat tortured history, and I think everyone would appreciate hearing just a little bit more about that.
Sure. Well, briefly, the Florida legislature enacted a law which prevented doctors from doing their job, at least where it came to guns. You know, doctors talk to patients, as you know, about all sorts of risks that, particularly that are faced by children in the home. Bicycles, wear your helmet, buckle your seatbelt, secondhand smoke. Florida's law said that if you did that with respect to guns, you could lose your medical license and get fined $10,000 for every offense. I mean, that's a shorthand version. They're, legislative language, but that's in essence what it did. A number of doctors in Florida contacted us, and we, along with law firm Ropes and Gray, brought a lawsuit claiming that the law violated the First Amendment. The First Amendment rights of both doctors and patients. Patients have a right to hear. That's part of the First Amendment as well. And trial court agreed with us, held that the law was unconstitutional. It was appealed to the 11th Circuit. They reversed 2-1. We filed an en banc petition. The court rewrote its opinion 3 times, which anyone ever heard of any appeals court doing that in the history of law? I haven't. And then the en banc court took the case and reversed 10-1 in our favor. One of the 2 judges that ruled it against us was a district court judge sitting by designation. So we drew the only judge that was against us in the entire court in the first go-round. But it was a great result, great decision. I commend it all to you, and it states clearly about the First Amendment rights of doctors, makes clear that this law and this sort of advising of patients has absolutely nothing to do with the Second Amendment. You have Second Amendment right under Supreme Court law, but that doesn't protect you from people telling you the truth about the risks that your Second Amendment right poses to you and your family. So we're still waiting to see if the state of Florida will seek Supreme Court review. That clock should run out fairly soon.
Daryl, I'll ask you to talk a little bit about the legal issues around the concealed carrying of firearms. Of course, as you mentioned, the Heller and McDonald decisions decided the issue of whether there's an individual right to have a firearm in your home, but it didn't. The court didn't decide the question of whether that Second Amendment right extends to possession of guns outside the home. And there's been a lot of regulatory action around the ability to carry guns in public places, as well as a lot of litigation. So can you talk a little bit about that and what your expectations are for one of those cases and the potential to reach the Supreme Court?
Right. So the issue in Heller and again in McDonald had to do with on its face only having a right to have a firearm in your home, and both of those opinions, but especially the Heller opinion, had an aside that said a prohibition on concealed carry is not really a Second Amendment issue. And the reason why it's not a Second Amendment issue is because there's been a long-standing regulation and prohibition in many, many states of carrying concealed weapons, and therefore that would count as sort of dangerous and unusual practices with respect to firearms. What the court did not address is whether there is simplicit or a right to carry a gun in some fashion outside the home. And right now, the way that that is likely to come up would be not necessarily as a facial challenge to a prohibition of carrying a gun outside the home, because I believe it's fair to say that most, if not all, states have some mechanism, either open carry or concealed carry or licensing of concealed carry, where a person has the ability to get a permit to carry a weapon outside the home. What it's likely to come up in is the division between what's known as may issue and shall issue. That is, what kind of showing must you present to get a license to carry a firearm, typically concealed outside the home. And incidental to that question, the court might in fact decide whether it's a right to carry a firearm outside the home. And if they do say that, then what kind of regulations can be put on that right. And I think that's most likely the way the case will present itself to the Supreme Court, although the cases that have come up so far, Peruta in the Ninth Circuit, Drake in, I think it's the Second Circuit or First, I can't recall at the moment, the Supreme Court has essentially declined to reach the merits of those cases.
Great. All right, let's go to questions from the audience. The first question is about the National Rifle Association. Can the NRA be persuaded to help with the prevention of gun violence, or is the NRA simply a blockade to progress? I'm going to let any of you respond.
No. No, they can't be persuaded. I mean, the NRA members are much more reasonable and much more reflective of most Americans. I mean, you'll find that most NRA members support universal background checks, for example, and some other reforms. But in my view, the leadership of the NRA is not representing gun owners. They're representing the gun industry. In fact, they do things and they support policies that are completely contrary to the interests of gun owners. If you're a gun owner, you want a safer product. You don't want your kids to be killed by your gun. That's not why you're getting a gun. You're getting a gun to protect the kids in your home, perhaps. Maybe that's misguided, but that's your motivating factor. NRA prevents those safety devices from getting put in guns. So, the leadership, everything they do is aimed at selling more guns. And as a result, they will not support anything that could in any way prevent the sale of any guns. And they don't really care who is buying those guns because it's the same value of the dollar to the industry they represent.
And here's a related question, which you touched on a little bit when you talked about NRA members. The question is about responsible gun owners and how they can be engaged to support sensible regulations.
Well, I mean, I think a lot of them do now. At least they say they do. I don't know how active they are. I think one way that they could become more active is to appreciate what I just said about the NRA. I mean, Wayne LaPierre gets paid like $4 or $5 million a year to shill for the gun industry and to as I said, take away rights and safety from gun owners. I think the more gun owners understand that, and that this is not the NRA that their parents and grandparents joined for hunting and for firearms training and responsible gun ownership, I think you'll see more and more of a shift where they're going to start, quitting the NRA. And you'll see, I mean, George Bush famously tore up his NRA card with some extremist rhetoric from the NRA. I think, personally, I think you'll see more of that in the future.
I think this is a question for Daryl. So in the Dox v. Glocks case and in other arenas involving gun laws, there seems to be a suggestion that along with the Second Amendment right to have a gun comes a privacy right to protect information about your ownership of that gun. And so we've seen that in some state laws that restrict access to information about concealed weapons permit holders. Have you seen this issue about a privacy right around the Second Amendment right? Have you seen that in any of the decisions? And what do you think about that as a matter of constitutional law?
Well, definitely in the in the 11th Circuit opinion, and the motivation for Florida in passing the law was about sort of a privacy protection element to what they understood the right to keep and bear arms to include. As far as the Heller and McDonald decisions, they're fairly silent on the issue about whether there's some kind of analogous privacy right with respect to the firearms. And in fact, this is one of the great ironies of all sort of Second Amendment litigation. But if you looked at the sort of regulation of the militia when the Second Amendment was enacted in the 18th century, the kind of intrusions that would have been permitted by the government are totally unbelievable. I mean, you could have had an inventory, an audit of the guns that were in the community. Why? Because you're supposed to have a well-regulated militia, and they could actually say, "Come." A government official could come to your door, say, "Present your gun. I want to look at it to make sure it's in good condition." So all that sort of got thrown to the side in the Heller decision with this focus on the individual right. But so far, this is the difference between what we might think of as sort of constitutional politics, the use of constitutional argument as a political matter, and constitutional law. There is no constitutional law that per se says you have a privacy right adjacent to having a firearm. You just have a right not to have it taken from you unless you're a felon or committed a crime or something. But it's all part of the constitutional rhetoric that tends to be surround any issues about guns.
Great. Here's a question for John about bad apple gun dealers. The question is, what's the process to obtain a license to sell guns? And have there been efforts to make that process more stringent to try to protect against the bad apple dealers?
Well, the process does not involve very much. Essentially, you fill out a form if you're not a criminal and you pay the fee. There's not really much else. You don't have to do any training. You check a box that says you're going to obey the law. I may be missing a little bit, but that's essentially it. During the Clinton administration, they raised the fees for FFLs, and that decreased the number substantially. And so that was one effort. I mentioned some states are doing, adding some more, or thinking of adding more requirements. There's nothing stopping Congress, except for the obvious reasons, from doing that. If I ruled the world, I would, have a bill in Congress which said if you want to be a gun dealer, you have to do these responsible things. You've got to have insurance. You've got to have videotaping. You have to have training of your employees. Here's a manual for how you prevent straw purchases and things like that. Nobody's introduced that bill yet, though.
One last question, and then I think we'll close and move to the next panel. So many of us in this room are watching the hearings on the nomination of Judge Neil Gorsuch to the Supreme Court. And for any of you, I'm wondering, do we know much about Judge Gorsuch's record on Second Amendment issues? And Do you have any sense of what kind of justice he would be with respect to gun-related issues?
Well, I read some of Judge Gorsuch's opinions, and I think it's fair to say that he sort of scrupulously avoided sort of really painful Second Amendment issues in some of the cases that I've seen. You know, if you pressed me, I would probably say he's going to be, you know, fairly much in the mold of Scalia. He'll be an originalist when it has to do with gun rights. He won't be an originalist when it has to do with things like affirmative action or something like that. I don't think it's going to shift the court that much. What I do think is, you know, when we sort of think about, I mean, I think that Heller is pretty much entrenched, but I kind of thought that Heller was entrenched whoever was going to be at the Supreme Court. I was not one of the people that ever thought that had Clinton won, that Heller was going to be overturned. I see no prospect of that. I see no political party that's staking its claim on overturning Heller. Heller is here to stay. It's really what Heller means that we're going to be fighting about, not whether Heller is going to remain the law of the land.
And I would just add that, you know, assuming Gorsuch is just like Scalia, which is, you know, about as far to the right, to the pro-gun side as you can get, maybe not quite as far as Thomas, even if that's so, there's a good chance that this Supreme Court went about as far as it was willing to go in the Second Amendment area with Heller and McDonald. That's an open question, but I think, I mean, the big question is Kennedy, right? And I think there's a decent chance, and this is pretty much speculation, that Kennedy would not want to say that there is a Second Amendment right to carry guns in public places, and that there's a Second Amendment right to assault weapons and things like that. You know, I would put that as an over 50% chance that that's correct, but I don't know nearly as much.
I never know. I never know how to predict Kennedy. Never. So.
All right, let's thank our panel.